Good afternoon and welcome to the second part of our two-part webinar series, which provides an overview of the significant construction and adjudication cases of 2018. Our webinars will provide an understanding of the key developments in construction and adjudication practice and how these might affect your construction project disputes in 2019. So this webinar will focus on our chosen top 5 adjudication cases of 2018. And we will be highlighting the main facts and legal points from each, identifying specific lessons to be aware of for construction contracts and claims. Now, all our webinars are recorded and are available on our Vimeo site if you are not able to join us live or would like to listen again or share with colleagues. Before we begin, there are a few housekeeping matters to address. To minimise background noise, I have placed you all on mute. If you would like to ask questions, please do so using the webinar chat function. And in order to keep within the 30 minutes, we will be answering as many questions as we can at the end of the presentation rather than as we go along. So I am Nathaniel Buckingham, a solicitor in the construction disputes team, specialising in construction and engineering dispute resolution based in Edinburgh. I am joined by Lisa Ambrose, a colleague in my team. Our team regularly advises on construction contract issues and disputes across a range of projects and claims. We also pursue and defend adjudications for clients regularly too, so we therefore have a great deal of experience of adjudication, and it's this experience which forms the basis of our strategic advice and what we will share with you today. So I will now pass you on to Lisa, who will run through the agenda for today's webinar.
Thanks, Nathaniel. We will start today by looking at the case of S&T UK Limited against Grove Developments, where the English Court of Appeal considered whether an employer can raise an adjudication about the true value of a payment application prior to paying in the absence of a payment or a pay less notice. We will then look at the case of Vinci Construction UK Limited against Beumer Group UK, where the English Technology and Construction Court, also known as the TCC, had to decide whether there had been a breach of natural justice by the adjudicator in making his decision. We will go on to look at the case of Equitix ESI CHP Wrexham Limited against Bester Generation UK Limited, where the TCC considered whether works carried out prior to the contract being terminated fell within the definition of excluded operations in the Housing Grants, Construction and Regeneration Act 1996, which I'll refer to as the 1996 Act, meaning that the adjudicator did not have jurisdiction to make his decision. We will then look at the case of Gosvenor London Limited against Aygun Aluminium UK Limited, where the TCC looked at the enforcement of an adjudicator's decision that was purportedly based on fraudulent invoices. We will finish with the Scottish case of BN Rendering Limited against Everwarm Limited, where the Court of Session had to decide whether it had jurisdiction to enforce an adjudicator's award due to an exclusive jurisdiction clause which was included in the subcontract. While most of these cases are English, much of our contract law and many of the standard form contracts used for construction projects are common across the border. The English courts have a larger number of disputes and appeals than the Scottish courts, and therefore key lessons can be learned from looking at English cases, and these cases would likely be persuasive in Scottish actions. So we begin with the English Court of Appeal case, S&T UK Limited against Grove Developments. Many of you will be familiar with the smash and grab payment adjudications. This refers to a situation where a contractor has applied for payment, usually in an interim application for payment, but the employer fails to issue a valid payment notice or a pay less notice, as it must do so under the 1996 Act if they intend to pay a sum less than set out in the contractor's application for payment. In the absence of the required notices, the contractor's application for payment becomes the default payment notice, fixing the amount due from the employer to the contractor. In these circumstances, the contractor can commence an adjudication to enforce payment of the sum set out in their application for payment without the merits of the sum being considered. We mentioned at our webinar on the top adjudication cases of 2017 that following the case of Imperial Chemical Industries Limited against Merrill Technology, there will be circumstances where employers can challenge the value of interim payments as well as final payments, including the next interim payment cycle or a termination event. We've now seen a development within this in 2018 following this appeal. In terms of the background to the case, Grove employed S&T to design and build a new hotel at Heathrow Airport under a JCT design and build contract. In response to an interim payment application by S&T, Grove issued a payment notice which had clearly set out the basis of the valuation, however it was issued late. They then issued a pay less notice which, although issued on time, did not match up to the detail of the calculation. After the dispute was referred to adjudication, the adjudicator found that it was not a valid pay less notice as the detail was insufficient. The case was then referred to the TCC, which found that Grove had complied with the requirement to specify the basis of the calculation, therefore deeming the pay less notice valid. The court also held that upon payment, Grove was entitled to pursue a further adjudication to determine the true value of the works. This was an important development in smash and grab adjudications, as it meant that even in the absence of a valid payment or pay less notice, a payer can still raise a counter adjudication on an interim payment application, i.e. they can challenge whether the sum alleged to be due on an interim application is the true value of the works. The Court of Appeal followed the decision of the TCC and dismissed the appeal by S&T and found that Grove were entitled to bring a counter adjudication. They held that the court has the power to open up and revise a sum notified in an interim payment application if the interim payment application determines what is payable. Therefore, as an adjudicator has the same powers as the court, and there is no limit on the jurisdiction of an adjudicator that would prevent him being able to exercise that power, the adjudicator was entitled to do so. However, the Court of Appeal stressed that the adjudication provisions in the 1996 Act are secondary to the payment provisions, and therefore payment must be made following a successful smash and grab claim before a dispute on the true value of the application can arise and therefore be adjudicated on. While this appeal decision has confirmed that a payer can raise a true value adjudication even in the absence of a payment or pay less notice, it does not make it any less important for payers to ensure that payment notices and pay less notices are served correctly and on time. The Court of Appeal has confirmed that payment must be made to the payee following a successful smash and grab adjudication, which can be a sizable outlay for the payer, particularly as the sums involved in a smash and grab adjudication tend to be inflated. Further, although adjudication proceedings are swift, there is still a risk of the payee becoming insolvent after the payer makes payment on the smash and grab claim and before the payer's counter-adjudication proceedings are concluded. The payer is therefore obliged to make payment with no guarantee that these funds will be recovered if they are successful in the counter-adjudication. This decision is therefore an incentive to payers to administer payments promptly and fairly. Therefore, whilst the threat and consequences of a smash and grab claim have been diminished, they remain a useful tool for payees to recover swift payment and a strong incentive for payers to improve how they administer payment processes.
We will now consider the English case of Vinci Construction Limited against Beumer Group UK. So Beumer employed Vinci in 2012 under an NEC3 engineering and construction subcontract to carry out the design, manufacture and supply of Gatwick Airport's baggage handling system. By October 2014, the subcontract works were in delay. The parties' disputes around extension of time were referred to adjudication 7 times. In the 7th adjudication, the adjudicator found in favour of Vinci and awarded £9.5 million of liquidated damages as a result of the delay by Beumer. After payment was not made by Beumer, Vinci commenced enforcement proceedings and applied for summary judgment. Beumer challenged the enforcement, arguing that the adjudicator did not keep the requirements of natural justice in mind when writing his decision. They argued that, firstly, the adjudicator's decision included findings that were not consistent with findings from the previous adjudications. Secondly, the adjudicator did not give adequate reasons. And thirdly, the adjudicator had failed to order Vinci to disclose material from a previous adjudication between Vinci and another party, which Beumer wished to use to aid their position. Regarding the first argument, the TCC found that the adjudicator's decision was not inconsistent with previous findings because earlier adjudications had only dealt with the monetary value of certain compensation events. Beumer's claims for extensions of time in respect of those same compensation events had not previously been determined. The extension of time claims could therefore be dealt with in the latest adjudication, and the adjudicator was not bound by any previous decisions. The court also mentioned that whether the adjudicator's conclusion was right or wrong, it was no concern of the court on an enforcement application. The second argument was dealt with equally briefly, and the court held that there is no difficulty in discerning the adjudicator's reasoning. And finally, for the third argument, the court held that the adjudicator could not have been expected to order disclosure when he was not requested to do so, and nothing was put before him that would have required him to make such an order. Beumer was aware of the prior adjudication decision in 2016 and, since then, had referred 3 disputes to the adjudicator without raising any concern about a breach of natural justice occurring in relation to the prior adjudication. The court reiterated that an adjudicator's decision does not need to be the standard of a typical court judgment, but rather needs to be sufficiently clear so as the reasoning can be understood, regardless of whether the decision and reasoning is right or wrong. The court therefore found no breach of natural justice in this case. The issues considered in this case arise regularly in enforcement proceedings. The TCC's decision here demonstrates the court's ongoing commitment to upholding adjudication decisions by summary judgment to maintain the efficacy of the adjudication process. It also highlights that a breach of natural justice argument will not be viewed lightly by the courts. If such an argument is made against enforcement of an adjudicator's decision, the court will scrutinise the decision closely, and it will likely be a difficult argument to make. It is important that a party has considered the matter carefully before deciding not to comply with an adjudicator's decision, and equally understands the cost implications of challenging enforcement proceedings. Parties must also be careful when implying that an adjudicator's decision is wrong, as the courts will ultimately find any argument of that nature irrelevant when a party is resisting enforcement proceedings.
Next, we will look at the English case of Equitix ESI CHP Wrexham Limited against Beumer Generation UK Limited. Equitix employed Beumer to design and build the Wrexham biomass-fired energy generating plant. The project was slow and was making little progress, so Equitix sought a declaration that Beumer were not entitled to an extension of time through adjudication. The adjudicator decided in Equitix's favour, after which Equitix terminated Beumer's contract. They issued an interim account requiring Beumer to pay approximately £11.5 million. A dispute arose which was eventually referred to a second adjudication with the same adjudicator, who decided that the determination by Equitix was valid and ordered payment by Beumer of around £9.8 million. Equitix raised an action to enforce this second decision against Beumer. Beumer resisted enforcement on the ground that, amongst other things, the adjudicator did not have jurisdiction to decide the dispute because the contract included works for the construction of a biomass energy plant, which were an excluded operation under Section 105 of the 1996 Act. Section 105 excludes the assembly, installation or demolition of plant and machinery on a site where the primary activity is power generation. Therefore, Beumer argued, payments made under the contract involved payments for excluded activities, i.e. they were not construction operations, and so the adjudicator did not have jurisdiction. The TCC rejected this argument. The courts looked closely at the 1996 Act, in particular Section 104(5), which makes it clear that it is only part of the agreement which relates to construction operations that will benefit from the right to refer a dispute to adjudication. Therefore, what matters for the purposes of jurisdiction is whether or not some part of the dispute that has been referred to adjudication relates to an excluded operation. In this case, it was held that the works undertaken in the project prior to termination were simply preparatory works, such as the preparation of business plans and bonds, which are often undertaken in major construction projects. These works therefore fall under Section 105(1)(e) of the 1996 Act, which says that operations which are preparatory to construction operations are covered under the overall definition of construction operations. There had also been no excavation and no plant or machinery assembled, installed or demolished. It was held that it would make a nonsense of the Act if every preparatory or ancillary operation not expressly identified in Section 105(1) became an excluded operation. A key lesson that can be taken from this case is that the question of whether an adjudicator has jurisdiction or not cannot be answered based on a construction contract as a whole. It is a particular part of the contract in dispute that has been referred to adjudication that's relevant, and the list of excluded operations will be interpreted narrowly. The court will look at the specific works undertaken rather than the preparatory and ancillary works which commonly precede construction operations. Therefore, the scope of the contract will not be considered in any great detail by the courts in deciding a matter such as this. However, parties should still ensure that they demonstrate the existence of a construction contract if relying on the right to refer the dispute to adjudication.
Next, we will consider the English case of Gosvenor, London versus Aygun Aluminium. As some of you may already be aware, a party can resist enforcement of an adjudicator's decision through what is known as a stay of execution in England in certain circumstances. Such a stay of execution prevents an adjudicator's decision from being enforced for a period of time and can be appropriate where certain matters have occurred or information has come to light since the date of the decision. This is often based on the financial position of the winning party. For example, an award is made in favour of a party by an adjudicator. After the decision is made, it comes to light that the financial position of the winning party is so poor and such that if a final court decided that the winning party were not entitled to all or part of the adjudicator's award, that the winning party would not be able to repay that sum. So in that situation, the other party could try to resist the enforcement of the adjudicator's decision and ask the court to pause proceedings while the claimant's financial standing is assessed. Although a stay of execution is often based on the claimant's financial position, this case added fraud as an additional ground. So in this case, Aygun appointed Gosvenor to install cladding for a new hotel in Southampton. The works were delayed and the matter was referred to adjudication. The adjudicator found in favour of Gosvenor and awarded them over £500,000. Aygun resisted enforcement of the adjudicator's decision, claiming that the sum awarded to Gosvenor was based on fraudulent invoices. So the TCC had to determine, firstly, whether Gosvenor was entitled to enforce the adjudicator's decision, and secondly, whether Aygun was entitled to a stay of execution. For the first issue, the court referred to SG South Limited against King's Head Cirencester, in which the court held that, so far as fraud is concerned, it is or may be, depending on the facts, a defence in adjudication proceedings, as it is in court or arbitration proceedings. The court then applied the principles set out in SG South. Namely, in the case of an alleged fraud, a distinction has to be made between those which could reasonably have been raised during adjudication proceedings as a defence, and those which emerged after adjudication and were therefore not known at the time, so could not be relied upon or made. For those emerging after, it is then necessary to differentiate between fraud which directly impacts on the subject matter or the decision, and those issues which are independent of it. However, the court held in this case that Aygun could have relied upon the fraud as a defence in the adjudication itself. The claim that one of Aygun's witnesses was intimidated by employees of Aygun was the only element that could not have been relied upon during adjudication. However, it did not directly impact on the subject matter, so as such, the court decided that Gosvenor was entitled to enforce the decision. However, for the second issue, the court granted Aygun a stay of execution. There were questionable disparities between Gosvenor's 2016 and 2017 accounts, which Gosvenor provided no evidence to rebut in the hearing. The court found that it was necessary to look into the fraud allegations further and decided therefore not to enforce the adjudicator's decision until that investigation had been undertaken. The court said that if the evidence demonstrates that there is a real risk that any judgment would go unsatisfied by reason of the claimant organising its financial affairs with the purpose of dissipating or disposing of the judgment sum so that it would not be available to be repaid, then this would also justify the grant of a stay. Now, the court stressed that this new ground will apply to very few cases and will be extremely rare, in the words of the court. However, it will likely add a new avenue for parties seeking to avoid enforcement of an adjudicator's decision. The decision also highlights the TCC's willingness to grant a stay of execution if there is a risk that a party will not be able to repay an adjudication sum.
The final case that we will look at today is the Scottish case of BN Rendering against Everwarm Limited. Everwarm entered into a subcontract with BN Rendering for the installation of external wall insulation in Kirkcaldy. When a dispute was referred to adjudication, the adjudicator found that BN Rendering was due over £140,000 plus VAT from Everwarm. BN Rendering then sought to enforce this award in the Court of Session. Everwarm argued that the Court of Session did not have jurisdiction to enforce the award, as the contract in dispute gave the English courts exclusive jurisdiction to resolve all disputes arising from the subcontract. They argued that this exclusive jurisdiction clause overrides the default ground of jurisdiction which was relied upon by BN Rendering, which was the defender's domicile in Scotland. The relevant provision in the contract was Clause 14, which stated that, subject to any specific agreement to the contrary contained in the order, any contract governed by these terms and conditions shall be governed by and construed in accordance with the laws of England, and the parties hereby submit to the exclusive jurisdiction of the English courts. BN Rendering argued that although Everwarm's subcontract terms and conditions formed part of the contract, BN Rendering had not provided the necessary consent to Clause 14, required under the Civil Jurisdiction and Judgments Act 1982. Also, BN Rendering referred to the European Court of Justice case of Estasis Salotti di Colzani Aimo e Gian Mario Colzani against RUWA as authority for a signature being required for consent to an exclusive jurisdiction clause. They argued that because they did not sign the subcontract, the exclusive jurisdiction clause was invalid. BN Rendering's final argument was that Clause 14 did not identify which disputes arising out of the subcontract were subject to the exclusive jurisdiction of the English courts. The Court of Session held that it did not have jurisdiction to enforce the adjudicator's award, because Clause 14 allocated exclusive jurisdiction to the English courts in respect of all disputes arising out of the contract. A signature was not required to demonstrate that the parties provided real consent to the exclusive jurisdiction clause. It was sufficient that the parties' contract expressly referred to the terms and conditions. It was also held that there was no ambiguity in Clause 14. The reference to exclusive jurisdiction could not be construed in such a way that the English courts would have jurisdiction only in respect of certain disputes. The action was therefore dismissed. The key lesson to take from this case is that when seeking to enforce an adjudicator's award, it is vital to ensure that it is clear which court or courts have jurisdiction before raising an action. The result of the Court of Session deciding that it did not have jurisdiction in this case was that BN Rendering will likely need to raise a fresh action in the English courts to enforce the adjudicator's award, which will result in additional costs and further delays to the enforcement of the award. Also, as a signature was not required for the exclusive jurisdiction clause to be effective, parties intending to include such a clause must clearly demonstrate that the jurisdiction clause was agreed based on the construction of the contract.
So what can we take away from today? Firstly, 2018 certainly shaped the future of smash and grab adjudications. There has been a lot of discussion recently about the Grove decision, marking the end of smash and grab adjudications. Now, we don't take that decision that far. However, as we have discussed today, they do still remain a useful tool or threat, both for payees in terms of their cash flow, as they should be able to recover payments more swiftly, and payers who now have a stronger incentive to administer the payment process promptly. And as we've also seen today, it is important that parties to a construction project ensure that, firstly, the existence of a construction contract is properly demonstrated, and secondly, the part of the contract in dispute being referred to adjudication falls under Section 105 of the 1996 Act. This stems from the underlying importance of carefully drafting construction contracts and ensuring that both parties fully agree to everything contained in it, for example, on exclusive jurisdiction clauses. So we have now come to the end of this webinar, which we hope has been useful and interesting, and we still have a few minutes to answer any questions. So if you haven't already done so, please do type your question into the chat box now. And while you're doing so, I will just take the opportunity to let you know about our construction and infrastructure breakfast seminars coming up next month. Construction and infrastructure law experts there will discuss the latest issues and trends in the construction sector concerning approaches to contracting and claims, as well as anti-competitive practices and cartels. These will take place between 8 a.m. and 10 a.m. on Tuesday the 5th of March in Edinburgh and Thursday the 7th of March in Glasgow. We would of course be delighted if you were able to join us, so if you haven't already signed up to one of these seminars, then please do so by visiting the News and Events section of our website. This webinar has been recorded and will be available on our Vimeo site shortly, so if you know of any colleagues who haven't been able to participate today, or if you think this will be useful for anyone else, then please let them know. And we will be circulating details of the recording to the participants here after the webinar. So we do have a couple of questions. So the first question is, how often are enforcement proceedings necessary following adjudication? And I suppose that question probably flows from, we've heard quite a few enforcement cases today. I think the answer to that is sometimes you do have to go to court to enforce an adjudicator's award. Not often, though. It's a relatively rare event. Of course, it depends on the circumstances and the parties involved, whether one party is adamant that they're not going to go along with the decision of an adjudicator. What I would say, though, is that actually often, I suppose, adjudicators' decisions they may prompt something further in terms of the dispute process. So that might prompt a mediation or settlement discussions which resolve the matter. So there may be circumstances where actually the adjudicator's decision isn't implemented in full, but obviously informs the parties' discussions and settlement discussions at a mediation. So it may kind of, in that sense, I suppose it would supersede the adjudicator's decision. But sometimes it is necessary to go along to court and enforce adjudicator's awards where there are no further discussions and when one party is not complying with the decision made by the adjudicator. And the next question, we heard in Equitix against Bester there about excluded operations. So the question is, what are excluded operations under the 1996 Act? And excluded operations, so these are under the Housing Grants, Construction and Regeneration Act. these excluded operations are not subject to the provisions of the Act, so they don't, the payment and adjudication provisions of the Act don't apply to these excluded operations, although of course contracts may still make relevant provisions for payment and dispute resolution. And the Act sets out all of the things that are excluded and are not counted as construction operations, and include, just as a summary of examples, drilling or extraction of oil, extraction of minerals, for example, assembly and installation of plant or machinery for power generation or nuclear, water, or chemical production and transmission, and that's obviously the one that was the subject of the case we looked at today. Also, it's not a construction operation if you're manufacturing or delivering building or engineering materials, components, or equipment, unless there's delivered along with an installation requirement. So if it's just for pure manufacturing and delivering those types of materials, that's an excluded operation as well. And as we heard in the Equitix against Bester case, those excluded operations are interpreted pretty narrowly, and only the part of the contract or part of the works that applies to those excluded operations would be excluded in any case. Well, I think that's the last of our main questions, or as many as we can get through, I'm afraid. I do hope that you've enjoyed this webinar and found it informative and useful, and we certainly look forward to welcoming some of you to our breakfast seminars next month. Thank you.